What's up, everybody? We are back to discuss the most recent shenanigans in the YSL trial. Most of it is coming from yesterday when the judge openly, continuously reprimands the prosecutors. We're going to talk about how, while that could be a good thing in promoting justice, we have to make sure that it's actually giving the criminal defendants a fair trial. And is it? If it's not, will she ever grant a mistrial? Is another question. And then number three, is she just doing what Judge Glainville did? Reprimanding and disparaging these attorneys, and is it going to rise to the level where maybe she'll get recused, or what's the difference? We're going to talk about all that and more. I've got my dad on. Let's get to it. Make sure you guys hit that like button. What's up, Dad?
Hello, what's up?
We are going to start. Well, actually, I guess before we get to the clip, why don't you give a quick rundown of, as short as you can be, of what's happened over the couple days before we start to get to the clips where the judge just continues to hammer the prosecutor?
Well, the last couple of days have been consistency because they're consistent with the way Woody testified, consistent with the way Sledge testified, and the third guy, Little D, just testified. And all of them did the same thing. Whether they had plea agreements or whether they had immunity, they would say, I don't remember, I don't remember, I don't remember. They didn't remember the interviews. They didn't remember what they said in the interviews. They had different reasons for not remembering. Little D, one of his reasons is medication because he was the one that was real sick. You know, you can remember, and they took him out, actually literally out of the hospital to put him in jail. Then they got him out of jail and he went home. But he testified the same thing. He doesn't remember any of the things he said or any of the accusations he made against Thug or any of the things he said about YSL being a gang and gang wars and shootings and all of those things, again, consistently. All three of those guys testified the same way. All three of them denied any of the things they said in their statements. And what the state has been trying to do is trying to prove the statements were true and what they said on the stand was false. And they've been doing that and they're continuing to do it, putting on, for instance, the persons who interviewed them saying, yeah, they were cogent, they understood the questions, they answered the questions, they weren't all drugged out on medication or for whatever reason. They also had some forensic people testifying about the bullet casings that were found on the floor. They also had testimony about apartments being shot up or gambling houses being shot up. But again, the key witnesses that are going to connect all this together and make this a RICO tying criminal activity to these defendants, it seems like consistently all three so far have been big zeros for the state.
And that's also consistent, in my opinion, for the most part. Although, if you are just your average jury, and at this point you're like, we get it, these guys are in a gang, then maybe the state's winning the case. It all depends on how the jury views it all and if they can tell who's being frustrating and who's delaying the case. And there's no doubt that our new-ish judge has started to find out exactly who the problem child of the case is and who's making everything difficult. And while we have a bunch of clips to get to from yesterday, this first clip we're going to get to is, I think, from a week ago. And it is more of the same. It is the judge getting onto the state, and we're going to watch this and listen to this. And I have had some questions about, is she borderline disparaging the state attorneys too much? Is she going to get recused? And so as we watch these, I also want you to think about that in the back of your head, Dad, and explain why it's different, very different from Judge Glainville.
All right, Mr. Sharp.
Your Honor, what just happened was completely dishonest, disingenuous, misleading, and gross.
And you objected.
I objected, and I wouldn't have even thought about anyone doing this other than the fact that I've seen the prior behavior throughout this trial of this type of nonsense, where we try to trick a witness into think we're saying they, meaning three people, and then try to convince the jury that we're somehow including my client Shannon when it's clear that the witness is not following. That's what we're talking about, and it's disgusting. And I don't know how we cure it, but I'm going to move for a mistrial. I think it was completely intentional. Obviously, it was calculated. Obviously, when I asked for clarification, I would think anyone seeking the truth would gladly clarify. I'm seeking the truth. I would gladly clarify. No, it's sheepish grin. And then,
All right, I understand your objection, and I understand.
Also, just a couple things for context. Number one, this is all outside the presence of the jury. Number two, he is saying some pretty harsh things that lawyers don't always say about prosecutors, or lawyers don't always say about other members of the bar in the jurisdiction in which they work, where they're going to have other cases against them. They may be at conferences together, but all holds are barred here. No holds barred, whatever it is. He's not holding anything back. He is letting them have it, continue to let them have it, and say this is just who they are and how they are.
Well, and I've got to be honest with you, he really shouldn't use the language he was using. He had some good points, but you lose your good points sometimes when you use that kind of language, and you've got judges that try to keep civility in the courtroom so that people don't use that kind of language.
And I will say, one of the big things we've been giving kudos to for a lot of the defense attorneys in this case is their professionalism. Even in the midst of how miserable all this has been and how this is not how it's supposed to be. This is not a fair trial. You should be upset about that. You can be animated about that, but keeping it professional always reads better in the transcript and looks better when it's live streamed.
Understand what you were saying past that objection. Miss Love, I think
May I
one thing that,
respond?
no, you need to listen. I think that one thing that needs to happen is when an objection is made and you are given an opportunity to respond and I make a ruling, even if that ruling is, please clarify, that you then need to obey what my order is instead of continuing to argue.
Your Honor, when I ask for clarification and consideration, I believe that as an advocate and as a person who is actually representing the victims who have been victimized in this case and who is representing as much as actually more than an officer of this court, and I represent something, I believe that the state has as much right to express, to request, and to ask for consideration and for an allowance to ask the questions that it wishes to ask as the defense does. I believe, Your Honor, the objection that was made, and I understand what Mr. Shart said, but there are a couple of things at play here. One, Mr. Shart is well aware that Mr. Zachary has said that his client was with him. He has said it in the interview that I'm holding in my hand. He is not being honest with the court when he is claiming that Mr. Zachary had no idea what I was talking about. I literally said Shannon, Demikian, and Mutu, and I asked him how close he was with each of them.
Right. And then we went from that to his girlfriend, and then it was not unreasonable. And the objection could just be, vague, but it was not unreasonable to object to make sure that it was clear what the question was, who the they was in the question. And when I say clarify, that needs to be the end of it. And you need to ask a different question, rephrase the question, and let's move on. And there shouldn't
Your Honor,
be an
if-
issue with it.
Yes, Your Honor, if the state is not allowed to ask for clarification or consideration, that I
I don't know
understand.
what you mean by that.
Your Honor, when I
A
asked
clarification of my ruling, is that what you mean?
when I asked for permission beyond what the court has instructed, I did not know that I should not do that. So I won't do that anymore.
That's not what was going on.
Now, she's trying to
You're
set the
basically-
judge up for discipline here. She's trying to set the judge up, and that's not what the judge is saying, but she's trying to make a record to prove that the judge is biased. That's what she's trying to do. And the judge caught her, and she's gonna correct it right now.
It seems to say, I'm asking permission to do something other than what the court has just ordered me to do. And so if that's what it is, then no, you cannot do that. If you need clarification of a ruling, then of course you can ask that. And if you want reconsideration, then you can ask for that, but that does not need to go on in front of the jury. When I make a ruling, obey the ruling and move on.
Yes, Your Honor.
Okay.
Your Honor, I really haven't heard any explanation for what happened. I think it was calculated. I'm moving for a mistrial. In the alternative, Your Honor, I do believe that there needs to be a curative instruction, or at least it needs to be clarified who they was. It doesn't matter what he said in the past. He lied in the past. I've already said that. I know what he said in the past,
All right.
but what he's
We don't know, you don't know that he lied. You don't know what the truth is and what the lie is if they are inconsistent. And there may even be a reason for that. Although if they're virtually diametrically opposed, there probably is not an explanation. But when you say he lied, we don't know that.
Okay.
Just like Miss Love doesn't know when he lied.
Well, I'll put it like this. Mr. Stillwell was never charged.
I think that's a good point from the judge. It's like, we can't act like you, just because you say which version of his events you believe, that everything else has to be a lie. I do agree with the judge there with that response to the defense attorney.
With those crimes. And Miss Love was not asking about what he said in 2015. She was asking about today.
I understand.
And today, he was clearly responding, they meaning Mr. Garlington, and well, it's clear to me. I don't believe it's clear to the
Don't
jury.
talk while he's talking.
And I believe it needs to be clarified immediately because, of course, I will have an opportunity to cross, but I will probably not have an opportunity to cross for about 4 days. And I don't.
Another annoying reality of this trial is anytime you want to cross, so much gets forgotten. There's days in between. There's other people cross-examining. There's more direct for days in between. Have you ever been in an argument with somebody and they make 3 arguments at once before you can even respond to the first argument? It's like, well, hold on. I want to go back to your first argument. Then they don't even remember making their first argument. That's kind of what this feels like for the defense attorneys, just so hard. Most of the time we're cross-examining a witness either the same day or the very next day from when they testify.
Plus, remember, again, this is not the case here, but in this trial generally, we've got a hurricane that also cut out a couple of days of trial. So the jury was again gone for a couple of days. So there's all sorts of stuff that happens in this trial. So you can never know when you're going to have your chance to get up there and explain it.
I don't think we should be misleading the jury on direct.
All right, I'm going to look back at what the transcript says. I mean, and Ms. Love, you may, given that there's now a motion for mistrial on the floor, in assertion that you did things purposefully, you may respond to that.
I vehemently object to the mistrial. I vehemently object to any mistrial, and I beg the court to look at the transcript and see what I said right before I asked him the people that I just mentioned. And I would ask that the court, I mean, if the court deems it appropriate that such language is gross and all of the disparaging remarks made by counsel for the defendants are appropriate, that's one thing. But I'd ask that the court limit that type of behavior, which is, you know, not becoming of officers of the court.
I agree with that. It is not becoming. All right, y'all can take a break if you want to. I'm going to take a look at the transcript.
All right. And we're going to jump to yesterday, literally 0 minutes in, the first minute of the court, again, outside the presence of the jury, before the jury comes in, and hear how the judge just starts the day off yesterday and then basically continues the rest of the day under the same sentiments. Although I've already heard and seen some parts of today where she's not going quite as hard at the state. But Dad, why don't we do this before we talk about this clip? What's the major difference between her and Glainville? Obviously, Glainville was going hard at the defense attorneys multiple times. She's going hard at the state. What's the difference between that? And why is she less likely to get recused than Glainville?
Because she's being more careful in what she says. She's also qualifying what she says. Like the prosecutor tried to set her up saying, oh, okay, if you say I can never ask for clarification, I won't. She says, no, that's not what I said. So she is being calm. She is explaining her rulings. I think she's doing a really good job. And I tell you, she's denying the motions for mistrial. And she's doing that based on the fact that these errors, she is saying, do not violate the due process rights of the defendants. These are errors. These are mistakes. These are things we can correct during the course of the trial. So she's trying to be, she actually, I think, is trying to be fair, but it's obvious she's starting to lose it toward the prosecutors.
So the two biggest differences that I see is, number one, I've noticed maybe 20 times she's come after the prosecutor, never in front of the jury. I think she is always her sweet Southern self in front of the jury. Glainville was not. He said multiple disparaging things to the defense in front of the jury. That's number one. Number two, the reason Glainville was removed from the case was not because of those disparaging marks to the defense attorney. So even though he said it sometimes in front of the jury, that's not why he was removed. It was for this ex parte hearing. And then what he did after the ex parte hearing, he didn't do things appropriately with his recusal process, which she hasn't done. And I'd be shocked if she did at this point. So that's why they're just not going to end up in the same boat. I'd be very shocked. And again, the most important thing being she, from my estimation, I could be wrong, hasn't done any of this in front of the jury.
Yeah. And you covered it when you said the real key to his recusal was the recusal process.
Right.
That, he didn't get recused because of the stupid things he might have said, but it's the way he defended himself after the recusal motions were filed. That's really what got him kicked off.
Andrew said, did you see Steele argued Love waived work product? I did not see that. Did you see that? I don't know.
No.
I did not see that. I have not watched every day, every minute of this trial like I have so many other ones. But let's get back to this again. Outside the presence of the jury, right in the beginning of the day, you can see the timestamp is literally at 000.
She is on her way. There was, I think, some problems with traffic.
Okay, so, I mean, Ms. Hilton, Sunday, September 29th, 1:39 PM. Good afternoon. I hope all is well. Attached, you will find the media list for this week.
Then, Your Honor, I take full responsibility for that. I can address it. If it was sent, then that is on me. If it was sent out on Sunday.
Okay, well, anyway, luckily, the only person highlighted is somebody who's already been testifying, so it's not an issue for this time, but let's not have that happen anymore. Second, we do have a witness on the stand that we broke to handle Mr. Zachary for, so we need to be continuing with that witness and go ahead and finish up with that. In addition, you have even more last minute provided an updated transcript at what, 8:30 or 10 or something o'clock last night?
I don't have to use that. I can.
Okay, that's good because nobody's had a chance to be able to look at it or compare it or anything like that.
So the judge has been begging her since Glainville, really, to give this stuff ahead of time. Give them time to prepare. Tell them who's coming up the next day and the next week. Any exhibits, any transcripts. Make sure there's enough time for everybody to review them. And this is Monday morning, and at Sunday night at 8 or 10 o'clock, she provided a new updated transcript, and Love's like, well, I don't need to use judge. Judge's like, good, because nobody has obviously been able to review this yet. And this is just the first of many things that Love has continued to not be prepared ahead of time for. That's going to culminate in more comments from the judge in the future.
Okay. All right, so can we get Mr. Sprinkle over to finish up his testimony?
Your Honor, Mr. Sprinkle, so as I explained before, I called Mr. Sprinkle when we intended to call Mr. Zachary. Mr. Sprinkle's testimony, and in order to avoid him being called twice, we were putting in the interview of Mr. Zachary, given his continued pronouncements regarding his health concerns and other considerations. We were going to call Detective Gaither to simply get in the interview regarding Mr. Zachary. Mr. Sprinkle's investigation, if you will deal with some of the information that comes from Mr. Zachary's interview. And rather than asking the court to call Mr. Sprinkle twice.
Well, we're calling lots of witnesses twice, or you are calling lots of witnesses twice, so.
Your Honor, I'd ask the court's permission, since we do have Detective Gaither here, to allow us to put in Mr. Zachary's interview and to allow us to proceed after Detective Gaither with.
And what is Detective Gaither just going to be introducing the interviews?
She's going to be introducing the interviews. Primarily, that is the reason that we have her. She also confirmed, though Mr. Zachary was able to confirm some information about his phone number, another phone number. I told her that I don't expect to keep her very long. I don't expect her to be more than today, frankly. And yeah, that's it. And the other matter that I wanted to broach with the court simply dealt with the concerns that the court had that we broached briefly regarding some of the cross-examination testimony and some of the information in the interview with Mr. Zachary on the 5th of August, 2015, that we believe has addressed some of the concerns that the court had regarding.
I'm sorry, but I don't know what you're talking about.
So in my email to the court, I said that there were some matters that we would ask permission to address prior to playing the interview. Some of the portions of the interview that defense requested redacted, the court said that it needed sometimes foundational information before I went ahead and.
Okay, and I think that Ms. Persfield responded to everybody that we're not going to address that this morning before, and we know that the jury is going to be here and ready to go at 9, and I don't think there's going to be time to address all of that in the 5 minutes before the jury is here. Do you?
Well, there's one that I think we can. It's the first one that we have listed.
Okay, well, anyway, that is what I said we would address either at lunch or at the end of the day, correct? All right, and so for that reason as well, we're not really ready for Detective Gaither's testimony. So go ahead and call Mr. Sprinkle over and let's pick up with him, because we can't, if we need to do the whatever is or is not going to come in the interviews and it's different from what we had already made determination about, and we left some things for determination, we have to figure that out during the lunch break. So
yes, Your Honor. Will the court permit me to step out and make that phone call?
Yes, please.
And also, Your Honor, so will the court be permitting me or allow me to bring Mr. Sprinkle back after we get in the testimony?
I mean, it seems to me like that's been kind of the way this case has gone. It's that people get called back 2 and 3 times. So sure, you can do that with him too.
you know, I think what you can see in her arguments, she's not smooth. It's like she's got to remember. I mean, she just doesn't know what she's doing from moment to moment, and she really wasn't prepared for the argument she was giving this morning. She's just not smooth, and I don't understand if a trial is going on this long, how she can't know her case backwards and forwards.
Yeah, and the judge feels that way too. Okay, we're going to move to the next. So let me tell you what I'm doing in the background here for a second. So we're going to move to the next thing that wasn't turned over in time for anybody to get. This is Weinstein, one of the defense attorneys. But Andrew said, I can't find the clip, but they argued that putting the ADA sprinkle on the stand, they have made trial strategy an issue in the trial, thus waiving work product. And then Andrew has tagged us in a clip on Twitter or X of this discussion. So I'm going to try to pull that while we're listening to this, which is just yet another late disclosure by the state. And we'll hear, this is, you know, the buildup to the judge's crescendo later in the video we're going to hear, where she really loses it.
So what, 3 days ago, we got a Dropbox link with additional crime scene photos
3 days ago, they got this.
from a 2019 case, a 2014 case, and a 2015 case. These hadn't previously been provided.
Of what?
Well, I think you'd have to ask maybe Mr. Atkins or the state. One of them relates to, I just have APD case numbers. I think they could give you more detail.
Okay.
My main point being, these should have been provided in December of 22 at the latest. So I don't know why we're just receiving these now. And it seems to be my role in the case. I'm here to, once again, complain about late discovery, Your Honor.
Ms. Love?
Your Honor, I'd ask the court, since that is not something that will be broached this week at all, that the court allow us to address the matter when I have those files in front of me that Mr. Weinstein.
How about you get
referring
those
to.
files at lunch? Seems to me like
We
we're
can
going to
do
have a
that.
lot to talk about over lunch.
We can
I
do
mean, this is literally still before the jury started. This is, you know, minute 16 at this point, now more. And she's like, we can just talk about that later, Judge. It's like, no, this stuff should have been turned over years ago. Once again, we talk about it whenever the state wants to talk about it. So the defense just has to always be ready to re-prepare for all sorts of new information that's Dropbox to them over the weekend. I mean, just imagine trying a case like this. It's literally, how hard is it as a defense attorney to try a case like this and make it a fair playing field for your client?
You know, and again, I obviously am not standing up for the prosecutor, but everyone should keep in mind when they're listening to this, when they complain about not getting a photograph, the real key is, are they prejudiced by not getting the photograph? Not just the fact that they didn't get the rule doesn't say because you got late disclosure, the case blows up and it gets dismissed. No, that late disclosure has to cause you some prejudice. So everybody should listen to what the prejudice is for those late disclosure of those photographs. And he didn't say what the prejudice was when he complained. He just said, why did I get them late?
Well, the reason he's complaining about that specifically is because the judge has said you have to provide this stuff ahead of time, and they just haven't.
And the
And-
rules say it too.
What?
The rules say the same
Right.
thing. There's a written
And that's
rule.
the thing is, and people are saying, what's the difference between late disclosure and Brady disclosure? Brady disclosure is specifically something that's potentially exculpatory. That's different. Late disclosure is just like, hey, here's something else that could be bad for your client that we're just turning over now. And you still have to be able to prepare for it. You still have to be able to know what it is. And the defense gets to call witnesses too. So maybe they have a witness that's going to, nuke this piece of evidence that the state's bringing. They have to know that they need to call that witness. And the only way for them to know and plan out this trial is to know what the state's going to present. So if they keep, moving the target, it really becomes impossible to prepare and present a case for your defendant.
But that's the prejudice.
Right.
If you can show, Judge, I would have called the witness. Judge, I would have done this if they'd have given this to me timely. Then they've shown prejudice, and they have to do that.
Do that, Your Honor. And also, I will say that those are, to the extent that, of course, I will look back and make sure that they were not previously provided, but to the extent that they were not, the crime scene information that we have turned over.
Nan said, would he know if he's prejudiced? I mean, no, he wouldn't know because he said he didn't have time to look at all this stuff.
Well,
But
and
I do
listen,
think,
go ahead. No, finish.
I do think that he is trying to, and the reason he's bringing it up this way, and he even said, I'm sorry, I've got to be the one to whine about, more late disclosures by the state. But I do think that he has said this to the judge at this point because he wants the judge to just be like, nope, that's out. You can't do that, and just exclude it so he doesn't have to waste his time reviewing it. I think he's trying to take the tactic of, this is happening so often, Judge, you got to do something and sanction them at some point to not be allowed to continue to do this. Maybe this will be the time. I do think that's why he's bringing it up over and over again.
Well, there's two things here. One is there's the cumulative effect. In other words, yes, there's this one piece, but Judge, talk about this one piece and then talk about all the other things that we haven't gotten. So there's a cumulative effect for the prejudice. And another thing about her, how does she not know whether or not this was or wasn't turned over previously? I mean, how does the person, the lead prosecutor in the case, not know whether or not something she gave them last night or whenever she gave these photographs wasn't something they got previously? She knows she's going to get this objection. She should be ready for it, and she should be prepared to answer it. And she's not.
Honestly, I know how she doesn't know. There's so much going on in this case. This is horrible. This is not how you should ever try a case. It's way too convoluted, way too confusing, way too much going on. And that's why she just has no clue what she has turned over, what she hasn't. With this volume of documents, she has no clue what she's turned over and what she hasn't.
Well, she's got a staff, and we've seen how many people have worked on this case. Somebody in that group should know.
Is a direct result of matters and witnesses that we have added back because of the objections that have been made. And the CAD reports, I believe, have already been admitted as evidence. So there is nothing about the photographs that would create any delay or prejudice or anything of that matter, but I'll address it at lunch.
What were the dates?
These are cases from, according to what Mr. Atkins sent, 2019, 2014, and 2015, Your Honor. And Mr. Atkins, in an email to me on that same date, the 27th, indicated to me that these had not previously been provided to us. So we can discuss it at lunch as the court wishes, Your Honor.
Okay.
See, now, he knew that. He knew it hadn't previously been
All
reported.
right,
Why didn't she know it?
Miss Love, in your Sunday 6 p.m. email, you said that you were going to.
I do have to say, I mean, that sucks. She's working all weekend, every weekend. Everybody is. I mean, that sucks.
To forward later in the evening to counsel and the court the portions of Mr. Zachary's interview that you were seeking reconsideration of based or because of, I guess, the way he testified. I'm not in receipt of that forward. Did you ever forward what the actual portions are?
Your Honor, I think, no, I forwarded the transcript, the corrected transcript that I was seeking.
But you didn't forward the portions that you had that either I had ruled out or you had agreed would be out?
I did not forward those. There were.
And yeah, that's what you expected everybody to argue this morning without even knowing what those were. Could you please forward those at your earliest convenience so that we will know by lunchtime what it is that we're talking about?
Absolutely.
Excuse me. And I didn't receive the transcript last night.
Well, she's agreed that she's not going to be using the transcript because nobody's had a chance to look at it. So you don't need to worry about that.
Thank you, Your Honor.
But I don't know if somebody's going to be over here to assist you later in the morning, but as soon as somebody gets here, you need to get that taken care of. Okay.
Yes, Your Honor.
All right.
And so she says, yes, Your Honor, in a way that almost feels like I'll do what I'm going to do. I'll do my best. If I get to it, I get to it. If not, you can yell at me again tomorrow, because there hasn't really been a lot of change in behavior in 138 days of trial. This is the exact same stuff Glainville was on her about very early on in this trial.
So is Mr. Sprinkle out there ready?
He said that he needed 10 minutes from the time that I reached him. So
Tell him, text him now and tell him he needs to get over here right now.
he is, Your Honor. He is coming. He
Text him
literally.
anyway and say the 10 minutes, he can't have any more time. He needs to stop what he's doing right now and come on.
And the reason she's speaking this way is because Sprinkle is an ADA. Nina said, Big George, I have 3 questions. Why was ADA Sprinkle allowed to use his laptop on the witness stand the entire time? Why calling an ADA to the stand anyways? And if a judge says your poor lawyering can it get any worse? So save the last question because we're going to wait till that clip comes up. But it's specifically on the ADA. Why was he allowed to use his laptop? Why call an ADA?
You're allowed to bring, you could bring notes up there. A laptop in today's world, a laptop is the same thing as bringing your notes, but the prosecutor is allowed to, the other side is allowed to see what you look at in order to aid in your testimony. So he can bring the laptop if he needs it, but just that if he's going to look at something on that laptop, he needs to know it's going to be fair game.
Okay. We're going to play this clip that they tagged us on Twitter. This is about the work product potentially. So we'll take a listen to Steele's arguments here. I don't know what's in this clip. It's a 2-minute clip from Twitter.
grace the bench in this case, but Mr. Copeland's statement, which was admitted over objection on June 10th, 2015, he's with prosecutors, not prosecutors, police officers. And they specifically say, we don't want Shannon. He's a little fish. We want a big fish. And it comes out, I want Thug. I want to know where his money's from. This was embedded in the case by the prosecution. And Mr. Copeland testified, I knew who they wanted. And he said, whether it's believed or not is up to, obviously, the trier of fact. But Mr. Copeland said, I knew that I can get out of that interrogation room by finessing against Mr. Williams. And I lied. That's, short. That's a fair amount. But I was going through this last night and this morning, Your Honor. And if the district attorney's who's testifying, and he's an honorable man, if he's allowed to say what his conduct was, why he did this, why he didn't do certain things, they asked yesterday, or the court may have said, yeah, but you attacked why some people were indicted and some people weren't indicted. I believe that came from this honorable court. Then I would like to have, I believe that's a waiver of work product. I mean, we're getting very close to strategy, and they're revealing, they being the DA's office through this witness, may be revealing to an adversary, which waives attorney work product, what they did and why they did it. And if that's true, I just know myself, and I won't follow the law. I'm going to serve a subpoena. It'll be met with a quash, I'm sure. And you're going to have to go through all of the in-camera inspection of all emails, text messages, memos from meetings. I'm going to put Paul Howard on my witness list because this case has been languishing before indictment for approximately 7 years.
And then John said, prosecutors Love, Hilton, and Willis were put onto the Georgia's Brady list over the weekend. What does that mean, and how does this affect them? I don't know what Georgia's Brady list means. I don't know what that means.
It might have been a Brady disclosure by the state of Georgia.
I don't even know what that means. But
No.
so as far as the work product, I don't think it rises to that level. Nothing I saw really rises to the level where he'd be able to get access to all of that information as far as prosecutorial trial strategy. But it's a defense lawyer making an argument, and that's what they do. I don't see a lot behind that. Do you?
No, there's no chance.
Okay. All right. Let's get back to, we're going to watch one more clip kind of what happened in the day to the buildup, and then we'll get closer to the end where the judge really goes off. First, this clip.
Held a ruling on Mr. Zachary's Twitter feed that was states 526. Are you intending to introduce that such that we would need to take up the various objections that I believe Mr. Adams made, or no?
The Twitter feed, I would be, yes.
Yes. Okay. So is that something that we've not looked at all before now?
What do you mean, Your Honor?
Quindarius Zachary's, I mean, it looked to be pretty thick. That's all of his Twitter posts
It is.
for a
and
certain amount of time?
It is.
Okay. And is that something that the defense has seen previously?
It's been served in discovery.
Okay.
We have not had a chance.
We haven't had like an evidentiary, okay.
We've
So,
not, and if I may just add, we also were not put on notice. The court had requested that they give us the list of the witnesses and the exhibits that are expected to come in through those witnesses. That was not in the list of exhibits for Mr. Sprinkle's testimony.
okay. So I mean, this is a voluminous record. Is that fair?
It has 259 pages.
Okay. So I'd call that voluminous. So how are we supposed to just off the cuff deal with what may and may not be admissible in that?
Because I have a set and small number of specific ones that I intended to actually publish. I just wanted him to, I mean, I tendered the whole thing because he got it, but I can distill it down and abide by it, whatever the court's ruling is.
So could you share with us all of the, whatever parts you think actually you would like to have admitted and
Absolutely.
published?
Yes.
I mean, can you do that from now on without me having to beg you to do that?
Your Honor, the court does not have to beg me for anything.
Okay, I mean, let's just have it be sort of a standard, which I thought would have been clear anyway, but is apparently not, that you make it clear to everybody what parts of what exhibits you want in evidence so that we can then, if there are evidentiary challenges to them.
All right. So I knew this was going to happen. Okay. Everybody just relax. I'm really surprised Peter doesn't understand a Brady list. It's also part of the Broom pretrial motion. I know what a Brady list is. I don't know what Georgia's Brady list over the weekend means. Like, is it something that they disclosed in this case as Brady witnesses or something on the, I don't know what a Georgia Brady list is. Do you know what that is?
As I said, unless you're talking about the
I don't know what a
state of
Georgia
Georgia, I don't know.
Like a Brady list on a specific case, obviously makes sense. A general Brady list doesn't make any sense for me for a state that just like every criminal defendant would have this prosecutor be some kind of Brady witness and be an exculpatory witness on their case. That doesn't make any sense to me. So I don't know. So Georgia, they're published. So like as violating Brady. Okay. So you're talking about like a public reprimand. That's what it sounds like. Okay. So maybe you're saying it's a public reprimand. Oh, public acknowledgement. Okay. So in Florida, we just call that a public reprimand where, you know, the state or somebody and it happens with all sorts of lawyers. Whenever lawyers get disciplined or sanctioned, they call it a Brady list. That seems like, I'll have to Google it. Somebody
You know what that is? You know what, again, I know about Georgia Brady list, but if a police officer has been sanctioned for improper conduct in another trial or for lying, then that automatically becomes something that is disclosed if that officer testifies in another case. That's a Brady list kept by the prosecutors. That might be what he's talking about.
All right. So yeah, there is a list. Florida has one too. That's weird.
Yeah,
I've never
Florida
looked
has
at it.
one too.
So it's just everybody that has ever potentially done something wrong that's like a prosecutor or a cop that can be used against people.
Right.
Interesting. Okay. Just FYI for everybody's behind the curtain. That almost never gets used. That almost never gets used in real life or in real trial. All right, here we go.
Be able to sensibly discuss those. Is that something you can do for the court and for the opposing counsel in this case?
Absolutely.
Okay. So can you right now let us know so that while we're having our half hour, we can take a look at all of that?
Sure can, Your Honor.
All right, thank you.
You're welcome.
And the objections, as stated already, generally were hearsay, confrontation clause, and authentication. There's not going to be a confrontation clause issue. People's Twitter posts are not testimonial. But with regard to authentication and hearsay, I don't know if
He can set the foundation and he can
authenticate these.
I believe that.
Okay, maybe. All right. And then there may, okay, so let us know. How are you gonna let us know that? Because can you email to everybody the portions, or how are we gonna?
I can give you the specific page numbers.
Okay, and everybody else has a copy?
Everybody has this. Yes. When you say everybody else has a copy, I'm not sure what the court means.
If you give page numbers, they have a copy so that they'll be able to easily find and look at what that is?
If they look at the.
Do
that
you
they
remember?
have.
They have a link. Do you remember which link it is?
Yeah.
Can you let us know that, or at least them know that?
I'll just yes, I can.
Resending it would be great, and then
Okay.
pinpointing.
And perhaps telling us where it is in the discovery.
No, she's going to resend it, which would be easier.
Okay.
Okay, so you will do that and be specific about what parts you want in. All right, Mr.
All right. So now we're going to jump to closer to the end of the day where the fireworks start.
Posted by the owner or user of the account?
That was
Yeah.
all speculation, not object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to?
I
What
would
handle
renew
the
my
number
objection,
is
also
next to?
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And
Okay, when
Your Honor,
we were up here at the bench,
so, Your Honor, I'll ask additional questions that
And so everybody just, why it's way more careful and they're talking way more slowly. The jury is in the courtroom at this point. So you'll notice how they're all being very careful until the judge sends them out and then the gloves kind of come off.
think will,
sustained.
okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Those jurors are getting a lot of exercise.
Thank you.
Your Honor, so my well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting, this is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? I'm listening.
yes.
Would you put it up?
First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with, where's the phone number? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him to
Honor,
testify to that?
I'm asking him, and I understand the court, I'm asking him what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked, though. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments, that was the words, Your Honor. And again,
I mean, the judge is visibly mad here. You can tell she's visibly mad.
So
She's body
she
language.
was flat out lied to, and she
Well,
knows she was lied to.
I don't know if I would say she was flat out lied to. I think I can understand the prosecutor's argument that she didn't think it was hearsay. She wasn't going to use the phone number to prove the truth of the matter asserted. She was going to kind of ask, have you seen this phone number somewhere else? Whose phone number was it? Does it match that phone number? Not necessarily that this document was going to be used for the truth of the matter asserted. I definitely think it was potentially misleading the way that she discussed it up at the bench. I don't know if I would say flat out lied, personally.
I think the judge thinks she lied.
this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he saw additional information. The entire cross.
Remember one of the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked
I
it.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkles' actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
Another problem with her is like her arguments don't really make sense. Like I can't even follow what she's saying. So it just doesn't make any sense, which is probably what happened up at the bench too.
No,
She probably just said whatever she needed to say to win the objection and then did whatever she was going to do anyways.
And I don't know the document, but I tell you, I can even think of the right question to ask him.
Right.
There is a right question to ask him.
Right.
She does not have to ask it this way so that she violates that truth of the matter asserted hearsay. Just, was there a number? Yes.
Yeah.
And did you recognize the number? Yes. She doesn't have to get into the specifics of the number or whose number it is with this witness.
And you guys,
I just.
and you guys know I don't.
Go ahead.
And you guys know I don't watch every second of this trial, so I don't know all of the background and what happened with this witness or how we got here, but I can think of 10 different ways to ask about a number on a document that would not make it hearsay, that the document would not be purported for the truth of the matter that it's asserting. I guess she didn't do that, and maybe she did lie to the judge. It's unfathomable to me that this is the type of lawyering that's going on in this case. Honestly, it's hard for me to grasp this.
But Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. Here. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes.
So basically what she's saying is you're either lying, misleading, doing all this stuff on purpose that's shady to win, or you're just purely incompetent. That's basically what she's saying. You're incompetent, you're unorganized, you have no clue what you're doing. How is that possible? That's basically what the judge is saying to this lawyer.
And she gets a good lawyer trying a case. Bad lawyers that do it like she's doing it and piecemeal hiding stuff, saying misleading statement at the bench, they get no advantage. I mean, they're not going to win or lose a case based on being slippery. This case could be tried a lot quicker with a lot less time if, before the trial started, she had gone through and already pulled out the sections of the transcripts, pulled out the sections of the Twitter feeds, pulled all that out, gave a nice, neat book to the defense saying, look, you have all this stuff, but let me synthesize it down. This is all we're going to use, so we don't need to argue about the other 10 books that we've got out there. And that's the way to try the case. Cut it short, make it quick, And let's have, if we're going to argue motions, let's argue motions about the stuff that I want to put in, not argue motion about the stuff I don't want to put in, just to take up time. And that's why she's saying she doesn't know this case, is because she hasn't synthesized it down to what needs to be introduced in evidence to prove her elements of the case. She hasn't done that.
I don't get it. I honestly don't get it. And I pop into this trial once every week or two, and it makes my head spin and is not fun to. It's actually like, you know, a lot of this stuff I find like entertaining and educational, and I feel like I learn as I'm watching with a lot of this. Maybe that's why I'm not drawn to this trial. I find none of that here. It's so miserable. It's so inapplicable. There will never be a case I ever have in my life that will ever go like this. I know that I should never say never, but I know that that's not going to happen. This is one of one when it comes to cases. And the reason for that is it shouldn't be. Like a case should not happen like this. It is not a fair case to these defendants. It's not a fair use of taxpayer dollars. It's not an appropriate showing of the criminal justice system in America. And sometimes, guess what? And I'm not saying these guys are bad guys. They're all presumed innocent, but sometimes bad guys go free because prosecutors or law enforcement screw up bad enough. And from my perspective, that happened long ago in this case. That happened long ago. This case should be over. There is no way you can ever convince me that this crap is a fair trial. Like you will never be able to convince me of that.
This is a miserable trial. If I was in this trial, I would be depressed. It's so miserable. This judge is so depressed by this trial because it could be I don't want to say fun. That's a bad word to say for a criminal trial, but it could be a trial, a professional trial that runs smoothly.
It could be a battle. That's what you're saying.
Yeah.
It could be a battle between lawyers.
Legitimate,
Arguments.
a legitimate battle. Yes.
Yeah.
Yeah.
But
And this is not.
It's not. Like, this is crazy. This is not how it's supposed to be. We're not supposed to be like, this is such a bad look for the criminal justice system too. Like, we work with prosecutors all the time that we really like, that we're friends with, even the ones we don't like. There's a lot of respect, mutual respect. We know certain ones you got to watch out for. They might do this or they might do that, or they might argue an opening statement, whatever. But it's just, this is not at all what it's supposed to be like. From all these.
Go ahead. Everybody makes mistakes. I mean, yeah, you might forget to give a piece of evidence. I mean, it's a huge trial. There's a lot of evidence, and it's happened to me. All right, but when it's happened and the lawyers are really ethical and have been really ethical, when it happens, you say, you know what, that's a legitimate mistake. You know, I believe these guys did not intentionally hide this piece of evidence from me, that they legitimately made a mistake and forgot to give it to me. You can't say that in this case. You cannot possibly give these prosecutors the benefit of the doubt on anything they do.
And that's the other thing, is it's like, it's just been either allowed or not hit hard enough throughout the trial. Whitney asked, can you talk about calling witnesses back multiple times? Yeah. I mean, that's a good example that we just glazed over, didn't even talk about. That's like the 100th issue with this case. But for the most part, there are some judges that say, no, you call them, you get it done. And then if something happens, you keep them under subpoena, you can call them back. It absolutely is not the norm or something you should plan on doing, calling every witness back multiple times, because you can't create a schedule where the witness can testify in 1 day or 2 days straight to get all their testimony done. But it's like the incompetence and the disorganization or unorganization with how they've prevented this trial has just become a norm at this point.
And I think, again, over the time we watched it, there have been at least 6 people working on the prosecution side. We've seen at least 3 or 4 lawyers. There's been 3 or 4 staff people that have been sitting at those desks at various times. And she's the chief assistant. She can pull in the entire office if she wants to. She's got all the resources she needs to do this right. And it's a disaster.
Shanta said the former DA passed on this case. Why did Fanny go forth? Corruption. I don't know. I don't want to speculate on corruption. I do not want to get into politics. All I will say is it's not a surprise, or wouldn't be the first time that a prosecutor, a head prosecutor, a DA or state attorney went after a big fish to make a name for themselves or make them look good or get a notch on their belt. Wouldn't be the first time for that. Also wouldn't be the first time they were fighting for justice, if that's what they believe it is. And, you know, I really don't want to get into the politics of it. All right. So the judge comes back, and this is when I was like, oh, is she going to grant the mistrial? Obviously thinking, no, it's not going to happen. And we're going to get her answer to, is she going to grant a mistrial and why?
All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal.
So again, that's what you said earlier. Is it prejudicial? Does it actually prejudice or hurt the defendant? Or is it just an annoying, incompetent, unorganized way to try a case? And everybody's frustrated because this just seems so miserable and so slow and delayed and unorganized. But is it actually prejudicing the defendant, the evidence that came in? She says no. I probably don't disagree with her. But at what point do you stack all this stuff up to where it just becomes a trial that's not fair? And for me, it's already happened.
But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F 2nd 255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway based on that? Yes, potentially we get to that point at some point, but there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
Well, I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time, Your Honor. It is all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It's this constant hiding laws, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court. And I think that it does rise to a level now, but I understand the rule. But I think that we're well beyond it. And the reason I said promote these things is it's literally from the
Oh, I saw that. I know. I mean,
Nina said, is this just a Georgia thing? No, I don't think it is. I will say that certain prosecutors' offices do take on the life of the head prosecutor or the chief assistant, like ADA Love, who's the one training a lot of prosecutors and telling people how to do. Like the leaders usually lead, and the prosecutorial discretion and action usually comes from the top down. I would not say it's a Georgia thing overall.
I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team.
So this is the question that we had earlier, is the judge saying that it's poor lawyering, is there any repercussions for that, or what does that mean for the trial? But the jury's not in the room. Basically, I think this is the judge trying to say, can you guys please shape up? I've given you a million chances. Glainville gave you a million chances. Can you please get it together to the state?
Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and
I mean, what else could it be besides poor lawyering? doing it on purpose to make everybody miserable and punish everybody? I mean, like, what else could it be? It's not like helping her win the case by doing it this way.
Well, maybe you don't think so. She might think so. Love might think that being sneaky and slimy is the way to win the case.
But like recalling witnesses 3 times and having all these witnesses come up and say, I don't know, and having the schedule take a year, like that's good. I don't understand how that's good.
It's not you and me, but we're not her. And from what we're seeing, she might not think like we think on how you try a case. She obviously doesn't think like we think on how you do discovery and how you do disclosure. She doesn't think like we think on how you obey the rules. She doesn't think like we think on how you obey judges' orders or to conduct yourself in court. She doesn't think like we think. So I don't think we should presume anything with regards to Ms. Love.
We're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
It's renewed.
Thank you.
The Harvey rule does apply.
Yes.
See,
Renewed and denied.
the problem is that Love, for what say about the way she's getting away with it. She
So
is
far.
getting away with everything. Even though you have a judge here who is trying to do the right thing, Love ignores her. One of the things weeks ago that we heard, and we just heard from the lawyers, is that she has not given them a complete list of witnesses with the exhibits that those witnesses are going to be shown when they testify. That was weeks ago, and it still hasn't happened. She does emails on Sunday night disclosing things to lawyers for things that are going to happen
Well, I
on
mean,
Monday.
the disclosure on Sunday night, it's like if you're working it forever and you're continuing to try to stay ahead of the game and you're disclosing the list of witnesses and you're disclosing stuff that, is going to come up in a month from now or whatever. The Sunday night emails suck and it sucks for everybody, but it's like everybody's still working on the case. Sunday night emails have to happen. It's just, if that was the only thing, then okay. But it is one of 1,000 things they're doing wrong and not following the rules and not giving proper notice and just screwing these criminal defendants. That's the problem. It's one of 100 things. Nick posted, judges recused 1, motions for mistrial 41, most justified, motions in limine for Mr. Steele 63, sidebars 276, prosecutorial misconducts at least 1 per day. Just keeping track of all this is the trial by numbers. Oof. Reese's mom said the feds passed on it too. I'm not sure. I'm not sure if they did. Nina, again, is on the Sprinkle testimony. Why call an ADA? Never seen that. I'm frustrated with your answer. Sorry. The ADA was constantly reading and interacting with his laptop. How is this allowed? Go ahead.
This ADA was called because apparently he was involved in the actual investigation. And so that's the reason he was called, is he did some investigative work and they wanted to make the bridge between, I guess, 2 particular facts and how those happened. And I think it amounted to the phone number. And so they called him. That's what they called him for, is investigative work that he does. And sometimes, and I've done it and prosecutors do it, sometimes you have to get involved in the investigation because the law enforcement needs some direction. They need some advice on the best way to do it. And you're going to be the one trying the case. So you want to make sure they do it the right way.
So it's basically he was standing in the shoes of an investigator, because normally
Right.
you have an investigator do that. So he was just doing that. He wasn't actually trying the case. That's why they're saying it was not trial strategy, but it's not like they called Ms. Hilton to the stand. They called somebody that they used for a specific reason.
Right.
Okay. TJ, Peter, would this be a fitting case for jury nullification? If not, what would be reasonable? Honestly, I think my personal opinion, and Dad, I'll hear yours. This is more of, did the state prove anything? Do you know what's going on as the jury? Can you check all these boxes beyond a reasonable doubt? Are you confident that the state has proven what they've came here to prove to you? Or is it just a bunch of jumbled, unorganized mumbo jumbo that none of it actually fits together, and none of it's actually, most of it is impeachment from prior statements that they're reading to you? And is that enough to convict somebody of a crime like this beyond a reasonable doubt? That's kind of my thought as a defense lawyer with the misery.
I don't know if everybody knows what jury nullification is, but jury nullification is somebody committed a crime, but the facts of the case don't justify a conviction. And the jury feels like they should let them go, even though they may have committed a crime. Jury nullification is technically unlawful. You can't argue it as a lawyer, at least not directly. Some lawyers are pretty smart in how they do it, but you can't directly argue for a jury nullification. And a jury nullification goes against the jury instructions. They're told if a crime is proven, they have to find the person guilty. And jury nullification is just the opposite of that. A crime is guilty, but a crime is proven, but they find the person not guilty. I don't think this is a case for nullification, because if they really prove the crime here, and again, it's a RICO, and they've got murders, and they've got all sorts of stuff. If they prove all this stuff, I can't see how a jury is going to say, okay, they proved that these guys murdered people, but we're going to let them go because the state was just so bad.
Katie said, this is just my personality, I guess, but defense counsel held back way more than I would have, because this is all microwaved BS and an embarrassment to us all, common sense. I think there's a way to do it, and there's a way to do it professionally. You don't want to piss the judge off. You don't want the judge to be mad at you as a defense attorney. It doesn't help you at all. So there's certain lines you don't cross, but I do think that the defense attorneys have been rather zealous throughout their representation in this trial. Nina said, was the last statement from the judge a hint of a mistrial? I don't think she wants to mistry this case. I don't think she wants to grant a mistrial. What do you think?
She doesn't want to do a mistrial, but it was a hint. I think she was telling the prosecutors, hey, if this gets bad enough, I'm the kind of judge, I might do it. So you better straighten yourself out. She was just giving them some warnings, which she's done 100 times.
Nick said, when I started covering this case in May of last year, I wore shirts and sport coats and had a well-trimmed beard. Now I'm streaming like a caveman in a Buc-ee's onesie, shouting at the screen. And to think you're not even sitting in there in court every day with these lawyers having to sit there and just listen to everybody drone on. I mean, you can get up and go do whatever you want. You can watch a TV show at the same time if you want to. That's brutal. That's brutal. Nita said the next full moon, the judge is over it. Reese's mom said, have either of you had a tongue lashing from a judge? I know you've had plenty, so I'll let you.
Yeah.
You can
All
think
the
about
time.
and pick your favorite one. The closest one I've had is in a hearing. A judge basically scolded me, not reprimanded, but scolded me for filing a sanctions motion against another lawyer who absolutely violated the rules. The judge found that she violated the rules, but we just don't do that to each other, is basically what the judge said. And I was so pissed off because this other client was dragging my client through the mud for no reason, wasting everybody's money. And that's exactly how the case ended up ending. But what's interesting is that same judge, about 8 years later, told me that the closing argument I gave at a trial 2 years ago was the best closing argument she's ever heard in a trial. So that was cool. So it's cool turnaround from the same judge that gave me the closest thing I've gotten to a tongue lashing. Do you have one you want to tell?
Well, I've had multiple contempt hearings where judges were going to hold me. I've never found guilty of contempt, but I've had multiple hearings where judges want to find me in contempt. Now, the biggest tongue lashing I got is when I was actually the chief of the criminal division for the U.S. Attorney's Office, because I was representing the U.S. government. Some judge was giving one of my assistants I supervised a lot of trouble in trial. And I came down when the jury was out and said, Judge, I want to sit down and I want to talk to you about the way you're treating this assistant. And he just ripped into me. And I said, Judge, can I respond? And he goes, no, get out of my courtroom. And that was the end of the argument.
It's federal judges, appointed for
life. It's a federal judge.
Like they can do whatever they want pretty much. It's like, what are you going to do? You can't, they're going to be there forever. All right. We're going to hit a couple quick questions, then we got to run. Katie Picos, what about what is right and wrong? Have I taken crazy pills? How do we not do better at this point? I've taken and passed the New Mexico bar, so that should say something. Yeah. I mean, I agree. I think at this point they've screwed the pooch and it's over. Like, I don't think they should go forward in the interest of justice. That's my opinion. But guess what? My opinion doesn't matter because I'm not the one making the decisions on this case. But if you were the decision maker on this case and all these defendants would be like, yeah, we're not going to sue you if you drop these charges and you cut all these charges, wouldn't you be like, good enough?
The problem you've got all these cases is the appellate courts always say it's best to make a decision based on the facts, not on all the other junk that's going around in a trial. They don't like mistrials at the appellate courts. They want a jury verdict. So, and she's doing it. She's trying very hard to get this to a jury. So yeah,
No, I mean, like as the prosecutor, like if I was the head prosecutor and I was making the decisions, I'd be like, I'm done. This case is over.
and that's happened to me. You were here, I think, when one of those cases where we tried a case multiple times where we kept getting mistrials, and eventually it was the U.S. Attorney's Office, a federal case. Eventually, the U.S. Attorney's Office said, "Forget it. We've tried it twice. We're just not going to keep. It's not a good use of our resources to try this case 3 times. So we're just going to dismiss the case."
Michael said, had a jury nullification, which is a perfect example. A guy who smothered his wife with Alzheimer's after she begged him to do it. So technically he committed a crime, but the jury was like, she wanted him to do it. So jury nullification, we're not going to also put him in prison.
Yes.
That's the point, even though he did commit the crime. Good example, Michael. Have you ever heard poor lawyering from a judge? I've never heard a judge say somebody's poor lawyering. I've heard them say, get it together, or you need to be more organized. I've heard those type of comments. I've never heard a judge tell a lawyer that somebody's doing poor lawyering in the courtroom. Have you? You've been in the courtroom a lot.
Never have.
That's wild. I mean, that's not good. And she didn't say it specifically to Miss Love. She said members of the prosecution team.
Right.
Reese's mom said, glad to see Big George alive and well. He was in North Carolina during Helene, wasn't he? Yes, he was. Ava said, save for the end. Peter, can you please do a live or recorded for the disaster in North Carolina? You have a following that could help. Please, it's devastating. So Ava, we are actually in the process of currently getting a link together to do a match with a disaster relief charitable organization that does stuff in multiple states. I know at least Florida and Georgia, maybe North Carolina as well. I'm trying to put it all together to consolidate it to one spot so we can all come together and do what we can there. But it's taking a minute longer than I thought it would to get all that together. And I was doing some background on some different organizations because I want 100% of what we give to go to disaster relief. But we've got it and we're in the works on it. And this week we're going to be doing posts on social media and stuff to tell you exactly what we can do. And I'll be mentioning it in some of my videos once it's live. But yes, he got home safe driving. I mean, we were so incredibly blessed throughout the hurricanes and, everywhere that we have anything to do with it. It's wild, but so many of our friends and family members are dealing with a lot of stuff. So we're doing everything we can to help. And I know you guys are as well. But that's all we got for this one. Make sure you guys hit the like button. Make sure you subscribe. Tell everybody else who's watching this trial if they want to come check out our reactions to the judges' reactions. This is where they can get it. But until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.